All right, good afternoon, everyone. It's my great pleasure to welcome you to the 2024 Sumner Canary Lecture here at Case Western Reserve University School of Law. Before I introduce our distinguished guest, I'd like to share a little bit of background on this exceptional lecture series. The Sumner Canary Memorial Lecture is perhaps the law school's premier endowed lectureship. It was established to honor the memory of the late Judge Sumner Canary, a judge on the Ohio Court of Appeals for the 8th District, also U.S. Attorney for the Northern District of Ohio, and a partner at Canary and Walsh and later Arter and Hadden. The lecture is made possible by the generosity of Judge Canary's widow, Nancy Canary, who joins us today. The lecture has a distinguished and really remarkable history of guests. We have been honored to have hosted Justices Sandra Day O'Connor, Warren Burger, Justice Scalia. We've had, before they were justices, Justice Kavanaugh, Gorsuch, Amy Coney Barrett. They've also been, I think, relatively recent speakers, of course. So I'm going to introduce our moderator, then I'll introduce our guest. Our moderator is Professor Jonathan Adler, known to, I think, everyone in this room. He's the inaugural Johann Verhey Memorial Professor of Law and a founding director of the Coleman P. Burke Center for Environmental Law. He's curated this lecture series for the past 15 years. As I think everyone in this room knows, he is one of the most widely cited administrative law and environmental law scholars in the country. New rankings just came out, and we'll be publishing a little news item about that, but he's always at the top of that list among the top scholars in his field and has been for years. He was also recently appointed as a public member of ACUS, the Administrative Conference of the United States, a really prestigious honor that really is a credit to all of his expertise and the reputation that he's developed over the years as a scholar. And now to introduce our distinguished guest, the Honorable Elizabeth B. Prelogger, who's the Solicitor General of the United States. Her illustrious career in public service and her extensive experience in Supreme Court litigation make her an exceptional speaker for today's event. As the 48th Solicitor General, she has the critical responsibility of representing the United States before the highest court in the land. She was born and raised in Boise, Idaho. She received her bachelor's degree from Emory, then was a Fulbright scholar and obtained a master's degree in creative writing from the University of St. Andrews. She then enrolled at Harvard Law, where she was articles editor on the Harvard Law Review, and graduated magna cum laude. Following her graduation from law school, she clerked for Judge Merrick B. Garland of the U.S. Court of Appeals for the D.C. Circuit, and then subsequently completed consecutive Supreme Court clerkships for Justice Ruth Bader Ginsburg and then Justice Kagan. Her career at the Department of Justice has been distinguished by several key roles, including acting Solicitor General, Principal Deputy Solicitor General, and Assistant to the Solicitor General. Notably, she was detailed to Robert Mueller's investigation into Russian interference in the 2016 presidential election and obstruction of justice issues, and in that role she served as Assistant Special Counsel. In addition to her public service, Solicitor General Prelogger has an impressive background in private practice. She worked as an associate in the appellate practice group at Hogan Lovells, later became a partner at Cooley, and she focused there on Supreme Court and appellate litigation. She has served as a lecturer in law at Harvard, and she co-taught a course on Supreme Court and appellate advocacy there. She will share her insights through a discussion with Professor Adler on the unique and challenging role of representing the United States in the Supreme Court. We look forward to an enlightening conversation, and we are really so grateful that she took the time to join us here today. So please join me in welcoming Solicitor General Elizabeth Prelogger.
Thank you, Dean Rose, and welcome, since this is your first Sumner Canary lecture at the law school, and we're thrilled to have you. And we're thrilled to have you with us today. So I guess just to start, as noted, you're the 48th Solicitor General of the United States, the fourth-ranking official in the Justice Department, a position that's been held by an incredibly illustrious list of folks. I checked today, Justice Elena Kagan, Drew Days, Charles Freed, Robert Bork, Edmund Griswold, Thurgood Marshall, Archibald Cox, Robert Jackson, Charles Evan Hughes, William Howard Taft, who went on to have a bunch of other jobs, and of course the first Benjamin Bristow. And we know that fourth-ranking position in the Justice Department represents the federal government in the Supreme Court, before the Supreme Court. I was wondering if you could kind of flesh that out a little bit more about what that actually means in terms of what the Solicitor General's range of responsibilities are, kind of what it is that you're responsible for besides making those oral arguments in the court.
Sure. You had that long list. Now I'm feeling a little bit of imposter syndrome. So it's a good way to start it off with an easy question about exactly what the Solicitor General is. Let me just say at the outset, though, I am so delighted to be here. I'm really honored to be part of this lecture series, and I'm very excited to have the chance to have this conversation with you. So I think of the job as basically breaking down into three categories. And the first bucket of responsibility, and this is definitely the most public-facing aspect of the job, is to manage Supreme Court litigation on behalf of the United States. We are absolutely the most quintessential repeat player in the Supreme Court. The federal government participates in probably over 90% of the cases that the Supreme Court hears each term, often as a party, because sadly we get sued a lot. But sometimes we come in as a friend of the court, an amicus, if the court grants an issue that has wide-ranging ramifications and might stand to affect the interests and equities of the United States. So there is a lot that goes into developing our legal strategy in the Supreme Court, crafting our briefs, of course, oral argument. We always seek argument time in cases we participate in. And then also we have a big practice of trying to keep cases out of the court when we won below. So we are frequently in the position of having won in the lower courts and the other side ask the Supreme Court to step in, seek cert, and we file countless briefs in opposition where we tell the court that there's no need for it to use its limited docket to review a particular issue. So I think of all of that, kind of the meat of the Supreme Court work is bucket one. The part of the job that is actually quite time-consuming and important, but I think is far less publicly known, is managing our appellate strategy in the lower courts. And the way that this generally plays out is it's the responsibility of the Solicitor General to make a decision about whether we're going to appeal from adverse decisions in the lower court. So anytime, anywhere, if the United States has lost a legal issue and there's an interest in continuing to take an appeal and to further press those legal arguments, it requires my personal sign-off and authorization for us to do that. And the reason that we channel this decision-making through a central person is to make sure that someone is thinking about the broader stakes of the case for the government's interests as a whole. If you are a U.S. Attorney's Office here in Ohio, you might really be invested in your prosecution or think that an appeal is strictly necessary, but we're looking at it to also take stock of, what are the odds of making bad law on appeal, taking a adverse district court decision that's non-binding and turning it into a binding circuit court decision? Or are we making arguments in that case that are in some tension with what we're saying over here in New York or down in Texas? So there's a real point, I think, and value in having someone who's looking at the broader legal issues and cases with that wider perspective of litigation across the United States. So I spend a lot of time processing those issues. We call them appeal authorization decisions, and it comes up to me through a lot of process before I make the call on one of those. And then the final category is kind of the grab bag of everything else, and I actually love this part of the job. One of the things that's great about being the SG is I'm also, in many respects, an advisor, a legal advisor to the federal agencies and components of the federal government who are our clients. So if an agency is considering a massive rulemaking that is, definitely going to spawn legal challenges, we will often have the chance to plug in at an earlier stage, take a look at the draft rule, provide thoughts on litigation risk, and work with the agency to try to kind of get out ahead of thinking through what our strategy in litigation will be. And as an appellate lawyer, I especially like this because sometimes you inherit a case and the facts and the legal decisions that were made along the way narrow your path to victory or affect the arguments that you could reasonably make on appeal. And it's very rewarding to have the chance to get involved in a case at an earlier stage and be able to help craft that legal strategy and make sure that we are preserving the arguments and making the arguments that we think might carry the day if and when a case gets to the Supreme Court.
And insofar as you're involved in authorization of appeals, kind of what determines the degree of involvement? So every now and then you'll see a case in a circuit court, and rather than someone from civil appellate, it might be someone from your office. I mean, is that just a question of cases that are particularly prominent, cases that are expected to go to the Supreme Court, so that you want consistency in litigation?
Yeah, so we generally focus the majority of our efforts on the Supreme Court and Supreme Court litigation. And so even in a situation where we've been very involved in authorizing an appeal and reviewing draft briefs, we regularly consult with the components and offer our perspective on cases. Usually they have primary litigating responsibility when the case is still in the lower courts. And the most common scenario is that they'll be the ones presenting oral argument and have the pen in terms of taking primary responsibility for the brief. You're right that there are a handful of circumstances that are often kind of ad hoc, where my office will step in and we might have an attorney in my office give the oral argument, and that can happen for a variety of reasons, sometimes based on what we expect to happen at later stages of the litigation, if it's inevitably going to go up to the Supreme Court. But sometimes, the attorney will have invested a lot of time in coming up with a particularly important legal argument, and then the line attorney in the division retires from government, and there's no obvious candidate to do the oral argument. So there can be these one-offs as well.
And so when an agency loses a case and really wants that appeal or really wants that cert petition, can you tell us a little bit, obviously you can't talk about kind of specific examples, but we know that in a lot of other contexts, when there are disagreements within the executive branch, there are various processes to try and mediate those disputes. If the Department of Energy and the EPA disagree about something, there's a process for that. Is there something similar in if, say, the EPA really wants a cert petition filed, and for a variety of reasons your office thinks that that's not a good idea or it's not cert-worthy, or is that kind of within the judgment of the Office of the Solicitor General?
That's right. So that is one of my primary responsibilities in managing our positions in the Supreme Court, is to decide in the first instance what that position is going to be. And you're exactly right that a lot of times it tees up really hard decision points precisely because the United States has varied interests. We often have multiple different equities in an issue, and trying to mediate among those competing ideas about a case can present challenges because there are so many various ways that a case could affect the interests of the United States. And just to try to make it more concrete, the example I always use here is, imagine a case gets granted that involves a claim of workplace discrimination. Let's say it's a Title VII case in the private sector. So we're not a party in the case. We have, on behalf of the federal government, a lot of interest in the proper interpretation of Title VII. We have interest through our Civil Rights Division, which seeks to protect workers against discrimination and has some enforcement responsibilities. The EEOC obviously has deep expertise in this area and will have perspectives on the case. And so we might have enforcement-related interests that would lean in favor of supporting a worker in a case like that. But then, at the same time, the United States is the federal government's largest employer. We ourselves are sometimes sued and accused of workplace discrimination, and when that happens, our civil division represents the agency or the officials who have been sued, and we have defensive interests as well in making sure that the rights of employers are protected and the laws are properly interpreted in light of those defensive interests. So, you take all of that together and you get everyone in the room making recommendations, and sometimes we don't even have interests that are lining up on the same side of the V. There's just fundamentally interests of the United States that are so cross-cutting they could reasonably support coming in on either side. So what we do is exactly what you suggested, a lot of process. I am the ultimate decision maker in a situation like that one, and if I have recommendations that come in with these different perspectives, different ideas about what we should do, we have a well-worn process of having those recommendations reduced to writing so people get it out on paper and articulate their view of the legal issue and what side they think the U.S. government should support. Sometimes we have meetings where we'll get everyone in the room at one time and I'll be asking questions. Sometimes I find a way to thread the needle, and you can see that we've got some interest or stake over here that we're trying to protect, and maybe we include a footnote or write something in passive voice to try to, essentially try to protect the interests of the United States as much as possible. And a lot of what I do is trying to find that sweet spot or way to mediate among the interests to advance our federal government's interests overall. But sometimes you can't find the way to make everyone happy, and a lot of my job involves making a judgment about what I think is the legally correct answer that would best advance the interests of the United States, and making the call that that's what our position will be. So it involves saying no or disappointing agency clients on a regular basis. But I guess what I would say is that what I would never want to have happen is for one of those agency clients to think that they weren't heard in the process, that I made my decision without a full understanding of the relevant issues and interests of the government. And so I think the process is an incredibly useful tool to help me ensure that my decision making is informed.
So one issue that comes up from time to time, and that I know you've had to deal with and I guess answer questions about, is the government changes its mind, right? So some of the issues, especially that make up the Supreme Court, are questions that different presidential administrations disagree upon. And sometimes when there's a change in administration, the Justice Department changes its position. But presumably that doesn't happen in every case in which, if the Justice Department, if you've been filing the brief in the first instance, you might have taken a different side. And I'm wondering if you could say a little bit about how, and for those that aren't aware, there was a Senate hearing, I guess, where Senator Cotton, I think it was it Senator Cotton?
Might have Senator Grassley, I think.
I asked you about this, but...
I tried to block out the conversation.
No, of course. But can you kind of walk us through how does your office decide when a difference in opinion in a case is, or about a case, is large enough to justify changing position, and does kind of where the case is affect that? Like is there a difference between, a cert petition's been filed and maybe you now want to withdraw it versus, the merits brief's been filed in November and now it's January and oral arguments coming up and that brief doesn't represent the position of the administration anymore?
Yeah, so this set of issues and thinking hard about our legal positions and when to change them that was among the hardest parts of my job when I first started, because I came in as the acting Solicitor General on day one of the Biden administration, and we had pending, OSG had pending, a number of petitions and merits cases that involved signature policies of the Trump administration at various stages of litigation that required, a lot of thought and process about whether to continue to adhere to those legal positions in those cases. And I guess what I would say is I took those decisions really seriously, because it is not a small thing to change the legal position of the United States. It kind of goes back to that institutional role we have with the court, where we are regularly litigating in front of the court. And I think that it would do a disservice to the interests of the United States for the court to think that we flip on a dime, or that we are not being really thoughtful and deliberate in crafting our legal positions in the government. So there's definitely a thumb on the scale against changing the position of the United States. But at the same time, there are certain cases where routinely across administrations, you come at things with a different jurisprudential philosophy, or where there are very relevant factual changes on the ground that affect litigation. And I think in that situation, you can't just reflexively adhere to what was decided before, because this has a lot of impact, and it's important to try to make decisions at any given time that reflect your best view of the law and the interests of the United States. So there were any number of cases when I first came in that I'd mentioned where the agencies themselves were changing course as a policy matter. We had a border wall case, and suddenly they weren't building a border wall. Or an immigration case involving policy, remain in Mexico, or the migrant protection protocols, and DHS wanted to rescind that policy. And when that kind of thing happened, we had to decide, what to tell the court. We had to inform it of the changes and make suggestions about what to do with the pending litigation. But those weren't change of position cases, because we weren't going to the court and saying, we no longer stand by our legal arguments of how to interpret the relevant statutes. Instead, we were informing the court about the very real change in the on-the-ground facts. Then there was a whole separate category of cases where we had taken a position on the law, The facts on the ground hadn't changed, but the relevant people within the federal government had different perspectives of the law, and that was kind of the hard category of cases. And for those, what I did is I fell back on that process we were discussing. You know, I never just said, well, of course we're going to change our position on X, Y, or Z legal issue and snap my fingers and it's done. And we wrote memos. I solicited the perspectives and views of decision makers and policymakers and legal counsel across the federal agencies within the Department of Justice, and ran a very intensive, thorough process designed to examine those issues to make sure that if a case came down to it and we were going to switch, that there was a really good reason in service of the interests of the United States to make that call. And I did switch a number of positions of the United States, but you wouldn't believe how many times I was asked to switch the position and ended up saying no.
And are there certain kind of subjects where it's harder to change? Like, so one intuition I would have would be that, for example, something that implicates the scope of executive power might be, you're going to be less inclined to switch because there's a kind of a persistent interest in that the executive branch has apart from who's president. Whereas if it's, you know, the scope of the due process clause of the 14th Amendment, that's something that we generally expect different administrations are going to have different views on.
That's right. I think that there are probably certain topics or areas where there's more consistency in the position of the United States. Like criminal law is a good example of this. You know, we tend to have a pretty well-defined set of interests as an entity that prosecutes and enforces federal criminal law, and it's not totally unheard of, but it's relatively infrequent that our institutional interests would vary so much that there would be changes in criminal law cases across administrations. And then there are others where you're right, it's more common to see a change in position based on a very different philosophy about the law or the Constitution.
And I should just note, there were note cards that were distributed as folks came in. If folks have questions, write them down, pass them, get them to the end of your row and kind of hold them up, and they'll make their way to me, and we'll try and include some of those questions as well. So you get to make some arguments yourself and have a reputation as being a superlative oral advocate. Is it just, these are the coolest cases? How do you decide what cases you get to argue? It's just like, I really like this case. Are there institutional considerations?
There's a lot of tradition behind it. So by long-standing tradition, the Solicitor General usually argues once in every sitting of the Supreme Court. The court sits between October and April once each month over a 2-week period, and the SG usually argues in each of those sittings. And the SG is supposed to argue the case that is most important to the United States. And a lot of times that's going to be the case that's highest profile and is, the front page news and is most closely watched across the country. There's a lot of correlation or correspondence there. But sometimes there are cases that I think for institutional reasons are profoundly important for the United States, even if they're not going to be front page news. And the example I always use for this, which is going to be close to Professor Adler's heart, is a case called United States versus Texas. I have to be more specific because it turns out I have argued 2 cases called United States versus Texas and one called Biden versus Texas.
You mean more.
Yes, and there might be more coming down the pipe. But this particular United States versus Texas was a case that involved the legality of removal priorities that the Department of Homeland Security had adopted for purposes of enforcing the immigration laws. But it also involved really key questions about the ability of states to sue the federal government, so the state standing issues, and then also big issues about remedies and entitlement to nationwide vacatur and other kind of remedial issues. And so this was a case that, the New York Times was not putting on the front page of any paper, but it was a case that involved really important cross-cutting issues for the federal government, where we are repeatedly making arguments at the threshold about the proper bounds of standing doctrine or about the proper remedies that courts should be awarding in particular cases. And it was my judgment that in that particular sitting, although it was not the most well-known case, it was the most important case for the United States.
You are correct that is very close to my heart. For people that don't know, one of the best issues to think about as a law student or a lawyer is the availability of nationwide relief under the Administrative Procedure Act and related questions.
You just perk up as soon as you hear it, right?
And I should note that the arguments she's made on this argument are correct, even if the court has not yet fully embraced it. But I was wondering if you could say a little bit more about that issue, like why that issue is more important, and the perception is that you were the first Solicitor General to make this as big an issue as it's become. Is that because something's changed in what lower courts have been doing, something's changed in the types of cases that are getting filed, or you realize that this was just something that really needed to be elevated? I mean, so I was wondering if you could say a little bit more about kind of why this is an important issue and why is it getting so much attention now?
Sure. I joked with Professor Adler before this that we could do a whole hour on remedies, but I promise you I'm not going to do that. But I can give you an elevator pitch for why this is such an important issue. These are really foundational issues about the proper role of courts and about how issues should be adjudicated and resolved in our society. And, there's really been in recent years a substantial shift in how lower courts have thought both about standing and about remedies. So I think of these issues as coming in pairs because standing is all about when you can ask the courts to intervene in the first instance. Our federal court system is based on the notion that you have to have an actual case or controversy, you have to have a plaintiff who's been injured, who has a right to sue, and bring that kind of issue before the court. And throughout the course of our nation's history, states have disagreed with the federal government about any number of policies, and yet they have not been able to come to court and ask the judicial branch to resolve those inherently policy-based and often political disputes. And so it's really been only in the last 10 to 20 years that lower courts have started entertaining suits by states and finding that states have standing. And it's a real issue or a problem because states regulate the very same people as the federal government. We have shared sovereignty over the people, and therefore anything the federal government does is going to have some kind of indirect effect on the state itself. It's inevitable that a federal policy is going to have some spillover effect or indirect effect on the state. And if that's enough for the state to have standing to sue, then suddenly the states can sue about anything. There will always be an entity, a state, that will sue. And the identity of the state changes. I often am facing suits by Texas or Louisiana, Ohio, Idaho. But in the last administration, it was California, New York, Hawaii. And so, this is actually a constant position of the United States. You said the issue's been associated with me. But the state standing arguments and the remedies arguments are actually very much a constant for the federal government because trying to ensure that there isn't this ability to kind of blow up any policy disagreement like this and embroil the courts in resolving it is, I think, something that affects the United States regardless of who's in power at any particular time. So that's the front end, state standing. And then on the back end, nationwide remedies. And the issue here is that, once again, our view is that it's inconsistent with the proper role of Article III courts and with the statute, the APA, that lower courts are frequently relying on as authority for granting these kinds of remedies. In the usual case, if a party comes to court and has been wronged in some way, the remedy fixes the problem for that plaintiff. But you don't go further as a court and give relief to the world at large or give relief to parties who are not part of that case. We have a system of party-specific relief. And our argument is that is that Article III, again, defining the bounds of the proper role of the judicial branch, incorporates those principles of party-specific relief as a matter of equity. And then when it comes to the statute, we have, very in-the-weeds arguments that I think are absolutely right, that Professor Adler has written on, that Congress, when it enacted the APA, did not grant an authority to act directly upon the agency's rule itself and to vacate that nationwide, again, because that would grant relief to non-parties. So this is a big issue because if you think about it, if you've got litigants coming to court on the front end and they have standing, and then on the back end, they can get relief that extends across the entire United States, it has real effects on the adjudication of different legal issues. It means that one district judge around the nation can decide for the entire country whether some important policy or rule is going to go into effect or whether it's going to be struck down across the whole country. And it means that the federal government has to run the table, because if we win in the first case and the second case and the 10th case, but then in the 11th case, the plaintiff gets relief and it's nationwide, it effectively overrides the decisions of all of those other courts that came before. So this is an issue that I think the Supreme Court has not directly grappled with yet, although a bunch of justices have started exploring it and writing about it and encouraging lower courts to think hard about these issues. But I think that although this is probably, not at the forefront of most people's minds about the great unresolved issues in the law right now, I think it absolutely belongs on that list because it really affects the course of litigation, and it's kind of a structural issue that I think has potentially profound consequences.
And in your view, is this related to, I guess, what some people refer to as the shadow docket? I guess some people like referring to it as the emergency docket, but there has been, it seems to be an increase in the number of filings that the court feels a need to respond to that are asking for some sort of preliminary or emergency relief and requires hearing issues on that more expedited basis. Is that driven by this other problem, or is there something else that you think is behind it? I mean, there's a lot of commentary about the increase in activity on the shadow docket. I'm assuming it makes a lot more work for you in your office. But I'm wondering, is this what's driving it, or do you think it's something else?
No, I think it's very much connected to this issue. And this has been a really substantial shift in Supreme Court litigation, again, in very recent history, just in the last 10 years or so, maybe even more recent than that, where the court is repeatedly being asked to resolve on an emergency basis these cases, where there are kind of fundamental stakes. And the court there hasn't been much opportunity for lower courts to weigh in. And the reason there hasn't been that opportunity is because if one court decides to grant a nationwide remedy, then it shuts off further dialogue or debate about the issue among the lower courts themselves. So I think that you're right that there's been a substantial increase of activity on the emergency docket. That docket's been around forever. There's a real need for it because sometimes you have to ask the court to weigh in on an emergency basis. But I think that the court itself, many justices have recognized that the current situation creates all kinds of issues because it means that often the court's being asked to make a preliminary merits determination in a rushed posture where there are frequently, kind of exploding deadlines where a policy is about to go into effect or where something's going to happen out in the world, and the court doesn't have the benefit of percolation in the lower courts because of the broad remedies they're granting. So, if the Supreme Court is out there listening right now, I think the solution to the increased activity on the emergency docket is to take on directly these issues about remedies. And I think once the court deals with that set of issues, we'll naturally see a decline in the need for emergency docket relief.
Some really issue, I guess, might be the timing or distribution of cases. So in relatively recent remarks, Justice Kagan commented that the court's work is very backloaded, that the court, in this coming term might be an example, doesn't grant a lot of cases in the spring. So the fall begins, the court has a relatively light docket, the court starts granting cases, the time to get briefing and hear them gets compressed, and then there is this tale that may be apocryphal that cases that are argued in April tend to produce less persuasive or less well-reasoned opinions because the justices are in such a rush to get them done by.
Someone told me they're more likely to be overruled, that someone did an empirical analysis and the April decisions, are less likely to stand the test of time because there's not much time.
Assuming that Justice Kagan is correct, this affects the court, the fact that the court's kind of traditional schedule of beginning on the first Monday of October and trying to have everything done by the end of June or first week of July, and not granting a lot of cases ahead of time so that things get compressed. Does that affect your office as well, in terms of the way you spread your work out?
So it doesn't have as much of a direct effect on us. Our work tends to be naturally spread out throughout the term because the court is granting cases on a rolling basis, and then those arguments are happening like clockwork month after month between October and April. And then, the real crunch, I think, for the court happens in May and June when all of the arguments are over. Our work is done, the cases are submitted, and we're just waiting for the decisions from the court. So I think that, we're like every other litigant who is in those last few weeks of June is watching day by day as the court's releasing decisions. And there's obviously some amount of work that follows the issuance of a decision, because then we have to analyze it and provide guidance to the field. And if it's a criminal law decision, that can trigger some follow-on grappling with the kind of fallout from that and figuring out next steps in litigation that's been pending or on hold. So we have some amount of that gets a little compressed, but I think I don't envy the justices in May and June. I feel like that's about the easiest time of the year for me, and it's probably the hardest time of the year for them.
Well, what about the fact that they just have fewer cases, right? So this past term, there were 59, opinions were issued in 59 argued cases, or 59 opinions in argued cases, because a couple were combined. When I was in law school, it was like 150.
Yes.
And if you go back to the 1980s before...
Were you walking uphill both directions as well?
In the snow, in sandals. But if you go back to the 1980s and before the elimination or the effective elimination of most of the court's mandatory appellate docket, there were terms with far more than that. What should we make of the fact that the court takes a few cases? Is this a problem? And other than granting every cert petition filed by your office, if it is a problem, what should the court do about it?
So it is really striking how the court's docket has decreased year over year. If you look at a chart, it's almost linear. It kind of predictably goes down by a little bit. And I think that it is to the detriment of providing guidance to the lower courts on the variety of issues. It's not that there aren't circuit splits out there or issues where the lower courts could really benefit from having the Supreme Court weigh in. But I think there are a couple of things behind it. So one is the emergency docket, which we've just been discussing. These decisions on the emergency docket, for the most part, don't turn into full merits cases, and so they're not counted in that tabulation, with some exceptions. Sometimes the court takes a case off the emergency docket and considers it on the merits on an expedited basis. But for the most part, I think the emergency docket is consuming a substantial amount of the court's resources. And I think Justice Kagan, spoke to that directly in the remarks that you referenced earlier, that they don't feel less busy, in part because they're doing so much work trying to resolve those emergency matters that come up. So I think that's part of it. I think the other part of it is that the justices write a lot more these days than they did back when they were considering 200 cases. I was reading recently, reading into a case, and I was reading a number of decisions that came, 1980s, and they were like 4 pages long, and no one wrote separately. They could just take a case and quickly get out an opinion, and these days that would be unheard of. I argued a case last term called United States versus Rahimi. It involved a Second Amendment question, a follow-on from Bruin. And I think there were seven different justices who wrote in that case. There was the majority opinion, and then there were a number of concurrences and also a dissent. And the number of pages the court churned out, it was incredible. It was a ton of work product and a lot of very careful thought. But that obviously interferes then with the number of cases the court can resolve when so much of the resources of the court are devoted to each justice articulating views like that.
So fewer law clerks, take away their computers, make them write the opinions out with a little pen.
Well, I guess the other thing I would say, the third thing I would mention, is that the court has had an extraordinary series of terms with a lot of big cases, and it's the big cases that tend to generate 200 pages of separate writing by the different justices, and there have been, I think, far fewer cases in recent terms that are the little legal issues. They're not little because they matter to the litigants, but the legal issues that are not going to be as high profile or maybe won't be as divisive. And I think there is a loss for the court and the lower courts in the country for the court not to have the bandwidth to take on those kinds of disputes as well. So, the court itself might be ready for a breather here, and I think that if the court was able to take on some additional cases that were maybe not quite as high stakes, that might free up more time as well.
Are those cases there? Some commentators argue that there are all these cases involving circuit splits on little mundane issues, and the court is just not granting them because it's worried about vehicle problems or I don't know what the reason is. And some people argue, oh no, there just aren't that many cert-worthy cases. Do you have a position kind of, again, other than the briefs where you want?
Certainly every petition we file is a true circuit split if one exists and should be granted. But putting that to the side, I think it's hard to generalize. Certainly, I think a lot of times the litigant who comes up to the court and petitions for review frequently is going to try to make the case that the case satisfies the court's criteria for review. I think a lot of times that's stretching things, and there really isn't a true circuit split. But there are any number of legal issues where I think the court could very reasonably grant the case that it sometimes turns down.
So, in a lot of cases, especially some of the high-profile cases, I guess a lot of the cases that you end up arguing, you're representing a Democratic administration. It's a court that has 6 justices, not appointed by Republican presidents, but that all tend to share a fairly conservative judicial philosophy. There's more uniformity in the judicial philosophy among justices appointed by presidents of the same party than, say, there was 50 years ago. How do you approach making oral arguments in cases where you have reason to suspect that at least the jurisprudential priors or instincts of the justices are contrary to those of your client or the federal government? I mean, does that create a different sort of challenge in terms of how you present something to the court?
I mean, we are very much thinking in every case about how we can craft arguments that could get us to 5 or more votes. I feel like this was a nice way of asking me a question like, don't you know sometimes you're going to lose, or how do you deal with that? Here's what I would say. We are very much in the role of advocate. We are seeking to persuade, and we take our cues from the court. So, there are a number of areas of the law recently where the court has signaled its views about the appropriate way to think about the legal principles that apply. Just to go back to the Second Amendment, for example, the court has made clear that history and tradition are the guiding principles there. And so we're not coming into the court with policy arguments. We're coming into the court now in Second Amendment cases with arguments based on history and tradition, because that's the legal test that applies. And we want to make sure that we are advancing arguments that we think that cohere with the relevant legal principles the court itself has announced. Think about statutory interpretation. I guess it was Elena Kagan who said, we're all textualists now. You're not going to come to the court in a statutory interpretation case and ignore the text or not make that a centerpiece of whatever argument you're running in the case. So we are thinking very hard about what arguments we can make that the court has signaled it's interested in, that it finds important in resolving issues that we think have the chance to persuade. But I never totally count us out. I mean, there are obviously areas of the law where I think we are sometimes facing headwinds. I'm a realist, and the justices have signaled their views or have articulated ideas about constitutional principles that are going to make it more of a challenge for us to defend what the federal government is doing. But I also think that there's a lot of room to try to persuade. I feel like in the old days when Justice Kennedy was on the court and he was the sitting justice, everyone would orient their arguments around what Justice Kennedy thought, and they would write briefs that would quote, Justice Kennedy's opinions and oral argument. They'd make eye contact and just hold it with Justice Kennedy. And it's not like that anymore, which I think the advocacy in the court is really fun in the sense that I am never counting a justice out for the most part. And maybe I think, that Justice Gorsuch might not agree with me on the merits, but maybe he'll agree with me on the jurisdictional issue I'm raising or on remedies. Maybe I don't know yet how Justice Barrett thinks about a particular issue, or I feel like I have the chance to persuade. And so we spend a lot of time thinking hard about our legal strategy and offering arguments that we think could appeal to a cross-section of the court.
But are there cases where you go on kind of thinking about how do we lose best? I mean, because I think that's an issue that advocates have to sometimes deal with and discuss with clients about, there are better and worse ways to lose a case, and how you approach that part of it, or are you always optimistic that there's a chance to persuade and you don't want to think about that?
No, I mean, there are any number of cases where I'm thinking hard about ways to limit any damage that occurs or to make sure that the court is aware of the consequences of different ways of resolving a case. So in any number of cases, there are better and worse ways to lose, and a lot of what we're thinking about is making sure that the court has the perspective of ways that its decision could call into question other things that it might not want to be taking on in that particular case, and finding off-ramps or ways to try to direct the court to a loss that would be less damaging to the interests of the United States.
An oral argument that was your favorite?
Oh, wow, my favorite oral
Or
argument.
the most challenging, or the one that was most meaningful?
Okay, I'm going to go with most, I like that you gave me a choose your own adventure here. I'm going to go with most challenging, because this is actually my best oral argument war story, which happens to be the very first argument I did when I was confirmed as Solicitor General. And believe it or not, it too was called United States versus Texas, but it was a different one than the one I already mentioned before. So this was a case, it actually connects up with several of the things we were just discussing. It was a case that came off the court's emergency docket. It involved a law in Texas that banned abortion after about 6 weeks when Roe and Casey were still the law of the land, so it was a clearly unconstitutional law. But the state had created this very unique enforcement mechanism that outsourced enforcement to private individuals instead of having the state enforce the law. And the reason the state did that was to try to box out courts from being able to consider the law's constitutionality in a pre-enforcement challenge. So it was a law specifically designed to basically try to prevent courts from being able to declare it unconstitutional. And this came up to the court in an emergency posture on the docket. The United States had sued Texas, saying this law is clearly unconstitutional, and we can sue, we have an action in equity to try to enforce these principles. And the court ended up deciding to grant the case and set it for argument just 9 days later, which is an extraordinary schedule in Supreme Court litigation. And because the court had actually granted the case, they ordered full rounds of briefing in that 9 days. So an opening brief, a reply brief, and an argument 9 days later. And at the time, I had been nominated as SG. I'd gone through my confirmation hearing. I was told that a vote would happen any time, but I had not yet been confirmed. So it wasn't clear to me whether I'd even be there in time to do the argument, but if I was confirmed, it was going to be important for it to be an SG argument. So I decided to dive into prep for the case and started reading into it. Actually, my first moot court in the argument happened during my confirmation vote in Congress, so I didn't get to watch C-SPAN and see my vote live. Means my mom was like the only person watching C-SPAN. But I knew I was confirmed because one of my deputies walked into the conference room in the middle of my moot court and gave a thumbs up sign, which was the way I found out. And then without missing a beat, the moot court panel, one of my colleagues, addressed me as General Prelogger in the next question, so right in keeping. That was a Thursday. The argument's Monday. But I still had to get sworn in as well, so we scheduled that for Friday, and that was the day our reply brief was due. So, we're scrambling to get our reply brief to the court. We file it at 5 p.m. that day. My swearing-in's at 5:15, so I literally ran down the hall of the Department of Justice to get over to the Attorney General's conference room. And the AG starts giving these nice remarks about how wonderful it is that I've been confirmed because I have this incredibly important oral argument that's happening on Monday, and it's like critical to the rule of law. And I'm sitting there thinking, I just need the ceremony to end so that I can go continue prepping for my argument on Monday. So I did not get that first weekend off of work, but this is where the story gets especially good. That Sunday, the night before the argument, was Halloween. And I have 2 little boys, and in my household, Halloween is a sacred holiday. The boys were, they made it clear, they were still pretty little, and they made it clear that it was a command performance for me to come along. So it's the night before my first argument as SG, where I've had very little time to prepare in this incredibly consequential case, and I am out there on the streets with my 2 boys. One was dressed up as a Rubik's Cube, and one was a doctor. Walking down the street, trick-or-treating. And my older son, the doctor, dressed up as a doctor, had told me he didn't want to stop until we got to 300 pieces of candy to be a PR for him. So, I'm usually one of those moms at every house. I'm like, just take one to the kids to remind them. But for this night, I'm like, handful's okay. I need this to be over. So then we run into one of my neighbors, and he's like, hey, what's going on with you guys? And I said, well, I just got confirmed as Solicitor General, and actually my first oral argument is tomorrow morning in this very important case. And he said, I guess women really can have it all. So that is probably both my most memorable oral argument experience, and also for sure my most challenging. And it was challenging on multiple levels. I mean, it was a very challenging set of legal issues. This was a novel type of state law, so on the law itself it was challenging, but also for these personal reasons involving having very little time to prepare and chewing up a couple hours trick-or-treating, it was a challenging argument on that ground as well.
Wow. So when you have the normal amount of time, I mean, there are a lot of students here, a lot of practicing attorneys who make oral arguments. When you have the amount of time that you would like to have, what is your general approach to preparing for oral argument? Is there anything distinct for you in terms of thinking about preparing for oral argument in the Supreme Court as opposed to another court? Do you have any, particular rituals or a bit of advice you'd offer to students and others who make oral arguments or hope to make them?
Yes, all of that. So oral argument prep for me is very much oriented around thinking hard about the questions and then working hard on thinking about my answers. Not for purposes of trying to memorize or, have some set piece that I can give, but really for purposes of trying to develop a comfort level with my case, a sense of fluency in talking about my case so that I can be ready for whatever the court throws at me. And early on, when I was arguing cases in the court, I would spend, inordinate amounts of time going down rabbit holes and thinking about issues that are really 3 or 4 levels removed from the central issues in the case. But as I've become, more experienced as an advocate, and also as time has shortened because I have to be efficient in my argument prep since I'm there quite often, I've realized that it can be hard to predict the out of nowhere question a justice might ask. But a full 90% or more of the questions you're going to get at argument will be predictable questions. They'll be the central issues in the case. A lot of my cases involve identifying our limiting principle or explaining, kind of the ramifications of the particular legal rule that we're asking the court to adopt. And it's often quite evident that there are going to be justices who want to press on that and ask me about it. And so I want to be ready to be responsive to that so that I can really listen to what they're saying and then try to come back to them with, a first order response of the most important thing they need to know in answer to their question. And then if I get a little more time, a second order response, a third order response, and so on. So I do a lot of work in my office, thinking hard about the questions, and then, really putting in the work to think through my answers and the architecture of my answers. And then we put it into practice with those moot courts, like the one I was describing before. The moot courts in the SG's office are, they're incredible. I mean, my colleagues are some of the best lawyers in this country. They are incredibly committed to public service and to helping their colleagues prepare for oral argument. And they're very experienced in this because they've all, they live and breathe the Supreme Court. They all argue cases themselves and they go to arguments frequently. So they can put you through your paces. And my goal is always to have a much harder moot court in OSG than the real argument, and for the most part, that's happening. Among other things, it used to be twice as long because we would do an hour-long moot, although these days, the court sometimes keeps me up there for over an hour, so I'm not quite hitting the time targets in terms of the endurance test. I do think rituals are important, so I kind of follow the same general approach to getting ready for argument, and then I have some practices I follow in the immediate, lead up to the argument. So one thing I do is I always try to go home at a reasonable hour the night before argument and have dinner with my family, because I feel like if you don't have your case locked into your mind by 7 p.m. the night before, it's probably not going to go any better if you stay at the office till 2 a.m. So I go home. We always have the exact same dinner before argument because I figured out perfectly what is the right meal to have to get nourishment but not an upset stomach. And then at the dinner table, the court now has advocates start off with a 2-minute introduction, kind of their theory of the case. So I always try out my introduction on my family, and then my kids rate me on a scale of 1 to 10. And I get some concrete feedback in the immediate lead up to the argument. And the first time I did this, it was actually a case involving the rescission of that immigration policy MPP that I mentioned earlier. And we had this kind of straightforward textual argument that the statute says may, but the lower court had interpreted it like a shall. So my intro focuses on the statute. It says may, not shall. And I finished my intro, and my older son, who I think was maybe 9 or 10 at the time, said, "Mom, I give you a 10 out of 10 because you said the statute says may, and I bet you're right. I bet if I looked at it, it would say may," which it does say this. I'm mom's really smart, right? And so then his little brother, who I think was 7 or 8, said, "Well, I give you an 11 out of 10. But I didn't understand anything you just said." So I said, "Well, honey, how did I get an 11 out of 10 then? for an incomprehensible argument? And he said, because we're a family and we support each other. So there's great inflation in my family for this oral argument tradition. But I think traditions are important. Oral argument is such an incredible thing. I love having the chance to argue in the court, but it's a pretty intense experience. And so I think that having whatever psychological tricks that work for you, or whatever dinner is just right for you, is the thing to go for. In terms of, sorry for a long answer, but you also asked about advice for people who are getting ready for argument. What I would say is there is no substitute for putting yourself out there. If you are in law school right now and you're thinking about appellate advocacy as an option, take those opportunities to do public speaking, look into moot court programs. It is, I think, can be very difficult to put yourself in that kind of situation where you are having to speak in front of a group, but I can tell you from my own experience that it becomes easier over time, and as you accumulate those experiences and realize that you're still standing at the end of it and everything went okay. And so I think really trying to reach out and grab those opportunities is one of the best ways as a more junior lawyer to generate the opportunities going forward.
So they should like it when they get called on in class.
Oh, they should love it.
So you mentioned your staff, and we have a question about this. The Solicitor General's office, how much of that office is political appointees? How much of it is career? Can you give a little bit more sense of kind of the composition of those folks that are grilling you at those moots?
Yes, so we are a pretty unique component insofar as there are only 2 political appointees in my office. The Solicitor General obviously is appointed by the President and Senate confirmed, and then the Principal Deputy is the only other political appointee not going through Senate confirmation. And everyone else in the office is career, including the other 4 deputies in OSG. So the way the office is structured is, we're pretty small. I think of us as being small and mighty. One of my predecessors once characterized the attorneys in the office as like the Navy SEALs of the DOJ. And I loved that. I'm like, I'm going to take that and run with it. We probably flatter ourselves, but we're like swooping in on these complex missions of Supreme Court litigation, and everyone is just so skilled and talented at what they do. But we're small. We don't have a ton of lawyers. And, so we've got 16 line attorneys. They're called assistants to the Solicitor General, and I actually got my start in DOJ in that role as one of those line attorneys in my own office. 16 of those, and then we have 5 deputies, including the principal deputy, who I'd mentioned before, but also 4 career deputies, some of whom have served in the office for decades and have amassed all of this institutional wisdom and knowledge of the traditions of the office and of government decision making, and they have trained, an entire generation of government lawyers, and it's an incredible resource for OSG, and we're just incredibly lucky to have those attorneys there. Also some newer deputies who have recently come in who are just amazing as well, and I hope will serve for decades to come, but none of them turn over across a change of administration. So there's a lot of consistency in the leadership of the office and also in the career staff of the office.
I've gotten some questions about current issues or pending cases, which I know you can't answer. There is one question that was asked about legal issues relating to transgender individuals. Some folks may know there is a case, a scrimetti from the Sixth Circuit, which is our circuit, that your office filed a cert petition in challenging, I guess it's Kentucky and Tennessee's.
Tennessee is the case the court granted.
Tennessee's statute prohibiting treatments for gender dysphoria for youth, so barring puberty blockers and hormones. And the court accepted the cert petition, arguing that violates the Equal Protection Clause. So there will be a merits brief filed in that case, which...
There has already been a merits brief filed in that case.
So that brief...
last week, I think.
Okay, so that brief can be found on either the Solicitor General's website or on the Supreme Court's website. We only have a couple minutes left. If you were able to, I don't know, it was like Back to the Future or something, you were able to communicate with your law school self and offer advice, things that you would want to tell yourself to do or not do, and so by extension, I guess giving additional advice to the law students here, what would that be?
Oh, I have so many things. I love this actually because sometimes I give unsolicited advice and now I can treat it as solicited. All right, let me narrow it down a little bit. So one of the things I would say, and this is again just kind of looking back on and reflecting on my career, every time I've gone to work at a place where I felt like I had people I could learn from, and then I just made myself like a sponge and tried to soak up the lessons I could learn from them. Every time I've done that, I have benefited so tremendously. So as you're thinking about your career options and your steps after law school, there are a lot of different paths that a career can take, and I think sometimes we tell ourselves that there's only one right answer at any fork in the road, and I don't really believe that. I think that careers and can turn out beautifully, and you can have a very meaningful experience with a lot of different trajectories. So I don't think there's like a singular formula, but I do think that trying to make it a priority to go to work at places, whether it's in the private sector or the public sector or elsewhere, where you really respect the people you're working with, and they have integrity and you have something to learn from them, and just being open to that, I think it can be super rewarding. It can help you learn, obviously, and it can help model for you what a lawyer can do when she takes whatever skills and talents she has and tries to channel it towards something that you believe in. So that'd be one thing. Another is to be kind. Especially if you're a litigator. Litigation is adversarial. You've got opponents and you disagree often very strongly on the legal issues in a case. But I really, really firmly believe that there is no trade-off between being kind and respectful and being a fierce advocate for your client and your client's interests. And the thing I always think about with this is there's kind of a tradition in the Supreme Court when you are at the lectern arguing your case of referring to counsel on the other side as my friend. And usually you gear up and start talking about my friend when you're getting ready to try to totally devastate the point they just made, right? But I love this because I just think it's reflective of this idea that you can be respectful of your adversary in the case and treat their arguments and ideas with respect, while also being very clear about what you stand for and what the legal issues in the case mean to you. So I don't think that you have to demean or use harsh words or harsh language to be a really effective advocate. And then the final thing I would say, and this connects up a little bit with what I was saying in terms of getting public speaking opportunities, is that, I think the best advice I ever received was to seize on opportunities to make myself uncomfortable. We are all, in this position where it's often easier to do the thing that makes you comfortable, to take the job opportunity that you're familiar with, that you already have experience with, that is not going to stretch you because it's a more comfortable place to be. But I feel like every time in my life when I have put myself out there and seized on an opportunity that made me push me outside my comfort zone, it has paid dividends. And so I would look, if I were you, for opportunities to make yourself uncomfortable and to just sit with that and embrace that ultimately as a step to really try to stretch and grow.
Well, I think that's a great note to end on. We've reached the bottom of the hour, and we don't want to keep you longer than that, even if the court might at times. But please join me in thanking Please also join us for a reception. Some of you that have been coming for a while are used to the reception being in the rotunda because there might be classes. We now have it upstairs in Ben Place, so it's right up the stairs that are outside that door. So please join us there. And again, thank you for